Hello, everybody. For those that are tuning in right about now, very, very happy to see all of you, and thank you for taking time just to allow me to share what my wife and I do here along with our team, which is to save families whose loved ones have substance use, mental health disorders, and failed attempts at recovery. Now, I'm planning to go to one. If you have to drop off a little early, I totally understand. If you are a lawyer and you're listening in, this is a Florida Bar approved program, which entitles you to 1 hour of credit. I give you that number at the end of the presentation. There's a half an hour of substance abuse and a half an hour of mental health, which as lawyers we now need. And so anyway, with that said, thank you very, very much for taking the time to tune in. And let's get into this because I know everybody has busy, and we also have a storm coming here. So there are two components really to what we do. This is the first of the websites that we have, which is the mentalhealthaddictionlawfirm.com. That is my amazing wife on the front cover with me. So that's mentalhealthaddictionlawfirm.com. And by the way, if anybody has any questions, feel free to put it in the chat. I will post my email address in the chat right now. So if anybody would like a copy of this presentation, just send me an email, and I'll be glad to share it with you, and any other resources that we have here. So I'm just going to put that in there right now. So mentalhealthaddictionlawfirm.com, and that part of our practice really involves helping mums and dads who call us from all over the country, as far west as Hawaii, and sometimes even outside of the country, and they have an adult child, 25 to 45, who's got a long history of mental health issues, substance abuse issues, treatment that never seems to work, visits to the emergency room for overdoses. And they come to us to solve that problem. And we're going to talk about today the three tools that we use to help those families. The other half of our practice is here. This is the Baker Act Attorney's website, and I'm going to talk to you more about that in a little bit. But this part of the firm is really focused on helping people who have been illegally detained into Florida's draconian, broken mental health system. And the Baker Act, which is Chapter 394 here in Florida, is our statute that allows the state of Florida to take custody of somebody when, as a result of some type of mental health issue, there's an immediate danger to themselves. And again, we're going to get to all of this in a little bit, but I wanted to just, show you that as the other half of the practice. But what's really important, as you'll see a little bit later, is that these two components, mental health and addiction law firm and the Baker Act attorneys, are all really part of one umbrella that we use to save families. So just a little bit about me. I was an assistant state attorney from 1994 to 1999. Not to age myself. Fortunately, I got hired pretty much right out of law school. I had interned there for 6 months in 1993, and it was the only job I wanted. Thank goodness they hired me. And it was an amazing 5 years. And then I left. But the reason I share this with you is because it really helped to shape not only the lawyer that I became, but this practice. And very early on in my tenure as an assistant state attorney here in Palm Beach County, I realized that something was seriously wrong because I was seeing the same faces over and over and over again. And each time the person came back, it was something just a little bit more serious. And here in Florida, even today, as it was back in the 90s, the mandate in our criminal justice system is to punish first and rehabilitate second. Now, back in the 90s, when I was prosecutor, we didn't have all these specialty courts like domestic violence court, mental health court, drug court, veterans court. We didn't have any of those things. We do today, which is great because now we can divert some of those people who we don't really want in the criminal system out and help them to get assistance for what is really sort of the underlying issue and why they keep coming back over and over and over again. So that's a little bit about me. My wife, Audra, she became my wife back in January. Lucky me. Audra practiced up in Massachusetts for many years. really is, I call her the guru of guardianship because she's quite brilliant, my wife. She really is. So we're both barred in Massachusetts. We handle cases up there from time to time. Our primary focus is Florida. And I'm also barred in DC, and we're both barred in federal court. In any event, that's just a little bit about us. So there's three components to what we do here at Astor Simovich. There's the legal component, and we're going to talk about that in this presentation. There's what I call law enforcement. So I have a phenomenal private investigator who has a team of investigators, and we use them because we get a lot of calls for missing people. We get calls of people who are out on the streets, and when we get a court order from a judge which authorizes the police to go and get somebody and pick them up and get them to a place of safety, we will normally do that pickup along with law enforcement because it's so much quicker. And obviously, if we have to go find them, we're going to do that ourselves, as opposed to asking the police to do it, because while we have nothing but love and admiration for our men and women in the uniform, they just don't have the resources all the time to go looking for people. They're busy out doing, criminal stuff, focusing on victims of crimes and things of that nature. So we give them a hand and we do it for them. And then when we have a court order in place and we find somebody, we will normally contact law enforcement and say, hey, we have a court order, please send 2 deputies now to execute this thing for us. So they're a critical piece of what we do. And the third part is what I call the clinical component. So I have two clinicians who are an immediate part of our team. They're sort of an a la carte option for families that want them. One is a licensed clinical social worker. The other one is a forensic psychologist, Evan Gershower and Dr. Robert Sanchez. You can find them on the Astor Simovich Law Firm website, which is actually, the Mental Health Addiction Law Firm website, which is our main website. You can also read about John, who is our investigator. And so they have become an important part of what we do. Because finding the right facility to put somebody in is absolutely key and critical. You want to make sure that somebody goes to the right place, they get the right treatment, and then they stay there long enough. Because if you send somebody to treatment over and over and over again, and they don't stay long enough, then you're going to find that getting them into recovery and keeping them in recovery is a very stressful, anxiety-causing situation, because it's just not going to happen. They're not going to stay in recovery. They don't have the skill set or the healing to maintain lifelong recovery. So the 3 laws that we're going to talk about today are the Marchman Act, Guardianship Statute, and the Baker Act. And those are the 3 legal tools that we use not only to get somebody into treatment, but keep them there long enough. Remember I said, got to keep somebody in treatment for long enough. Now, here in our firm, our goal is to keep somebody in recovery for 1 year. It doesn't mean you got to hire us for a year. It doesn't mean they have to go to treatment for a year, but we typically like to keep somebody in treatment minimum 90 days. We prefer 180 days, 6 months. And our typical Marchman Act case goes for 6 months. And if we can get somebody halfway there and then they start to work an aftercare program, which is sort of a combination of 12 steps, getting a sponsor, going to meetings, continuing with outpatient services, that can help to get somebody over that 1 year hump, by which time they've now developed a skill set that's necessary to maintain lifelong recovery. And not only does that give them time to heal, but it gives the family time to heal. And by the time a case comes to us, we know the family they're just about done. And as my late father told me, when anybody comes to a lawyer, especially with the work that we're doing, they're sort of at their wits' end. They're sick and tired of being sick and tired, and they're desperate for help. And you have to respect that. You have to honor that and understand where they're coming from and treat them accordingly. So there are 2 things that really changed the dynamics of the kinds of cases that we get. COVID-19, the pandemic, and the legalization of marijuana. So when COVID came along, just before COVID came along, really for the first 4 or 5 years that we had this practice. And when I say we, I mean just myself and my wife. I mean, really, for the first 7 years, it was just the two of us doing everything. It's the nature of when you start, of how, what happens when you start a business. But our cases, back in 16, 17, and 18 were really primary substance use disorders. And what I mean by that is that we were getting calls from families who had a loved one who had, some type of issue with, it could be marijuana, some type of other street drug like cocaine, heroin, meth, addiction to prescription medications, things of that nature. We did see some mental health issues, but not the extreme to what we see now. Okay. And what was happening during COVID is individuals couldn't get in to see their doctor, right? They couldn't get in to see their clinicians. They couldn't get any help. People that had not had issues before were starting to have issues. People who were in recovery were starting to relapse. And what was happening is they were calling 911, they were calling 211. They were showing up at emergency rooms for help. They were showing up Baker at receiving facilities for help. And the sort of dynamic of the cases shifted from primary substance use to primary mental illness, and it has remained that way ever since. The other big factor is the legalization of marijuana. Now, I'm a child of the 80s. I had a number of friends who used marijuana, and for the most part, they all seem to go on and have, successful and productive lives. The marijuana of today is nothing like the marijuana of when I was growing up in the 80s. This stuff is dangerous, and it is a gateway drug. And we are seeing a lot, just a lot of mental health related cases where there's marijuana use. If there's any kind of predisposition to a mental health issue, legalized marijuana, or for that matter, any marijuana, but the legalized stuff seems to be the most potent. It's like pouring gasoline on a fire. And we are seeing a lot of that, a lot of schizoaffective disorders, a lot of bipolar, severe anxiety, severe depression. I mean, you name it, we're seeing it. Suicidal ideations. And a lot of the time there is a legalized marijuana component to this. So one of the reasons we have these two amazing clinicians is to find the right facility. I'm not one of these lawyers who likes to have repeat business. I want to get it right the first time for you, because you came to me to solve this horrendous problem that is literally destroying your family, which is why they call this a family disease, because it is destroying the family. It's like a metastasizing cancer, and it is destroying the family. And so we want to get it right the first time. Okay, what is the Marchman Act? So the Marchman Act, which is Chapter 397 here in Florida, and this is a statute that's unique to Florida. There's really nothing else quite like it. They have Casey's law in Kentucky, but from what I've read, it's not nearly as potent as the Marchman Act. And the Marchman Act is designed specifically for when there is a primary substance use. So what that means is there has to be some type of drug use, and we have to be able to prove it. So when a potential client comes to us, one of the responsibilities that we have, we call it triaging the case or staffing the case, is to find out exactly what evidence we have. Do we have enough evidence to prove that it's a primary substance use? Now, we're taking calls mostly from mums and dads, and part of the conversation we're going to have with the parents is, how do you know your loved one's using? Now, a lot of the time parents will just say to us, tell us, why did we just know? In fact, right before I did this, this chat with everybody, I had a family that told me just that. They have a loved one who is using. Sounds like there's significant marijuana use, alcohol use, cocaine use, but nobody has seen this individual for a couple of months. Other people have told them he's using. He ended up in the emergency room because he had a seizure related to drug use. But that, the medical information, that's all going to be privileged, because we all enjoy medical privilege. And we have to make sure that we have those witnesses who are willing to come forward, because I can't just go into court and say, oh, well, Your Honor, this person heard from a third party that this is what's going on here. So I have to be able to prove it. So that's key and critical. And of course, Marchman Act also contemplates that there may be co-occurring mental illness. Now, who can file one of these things? Who can file a Marchman Act? Who can be the petitioner? Well, as a general rule, because we're only dealing with adults, not all the time, but 99.9% of the time, the respondent, the adult child, is obviously over 18. And that means that the parents, a friend, a guardian, anybody, pretty much anybody, any one individual with direct personal knowledge can be the petitioner. When we're talking about minors, it's typically going to be the parent or a legal custodian. That's who we're dealing with. But we very rarely see those cases. Maybe once or twice a year we see a case with a minor, but as a general rule, we're talking about young adults, 25 to 45. Okay, so what do we really talk about in terms of the criteria? What do we have to prove? Well, I put up the criteria here on the screen here, but let me just sort of summarize this for you. Primary substance use where the person appears to be just has no control over their substance use, right? They're not capable of making what we would consider objectively reasonable decisions. One of which is either they actually have an issue, and two, that they need to go to treatment, right? They're in complete and utter denial. And so that's what we're talking about here when it comes to proving the criteria for a Marchman Act. So you'll see here, I've put, it's a bifurcated process, meaning there's two parts, and then you'll see in parentheses 2023. So let me explain that to you. On July the 1st, there was a new Marchman Act statute for all intents and purposes. Some major changes were made. There was also changes to the Baker Act, and I'm going to talk about that in a little bit. But basically, there are still two steps to the Marchman Act, except it all has to be filed in one petition. It used to be we'd file two petitions, one for assessment and one for treatment. Now, it all has to be done in the same pleading. And if you don't plead it, you've waived it. So one of the things that we did, I think it was on July the 2nd, is we went in and we revamped, rewrote the petition that we were going to use for these new cases. And I will tell you, it really had a problem because the clerks didn't know how to handle these cases. The judges were all getting up to speed. The lawyers were all getting up to speed, but we've really been on top of this stuff, and we had to change our pleadings to make sure that, frankly, they were legally sufficient, meaning that we actually had the right information there to give to the court. Otherwise, it was going to get dismissed. There are still two parts to it, though, assessment and treatment. So it used to be, and you'll see here, it used to be an assessment order was good for 5 days. It's now only good for 72 hours with exceptions. And I'm not going to get into all of that today, but needless to say, you can, in theory, go from 72 hours to 10 days based on the facts and scenario that's presented in the case. Okay, so you've got the period of assessment, and you also have the period of treatment. Now, what's neat about the assessment is that it can be started on what's known as an emergency ex parte basis. What does that mean? It means that we're going to file a request for an assessment order. There's not going to be a hearing, and we're going to ask the court to skip all of the due process requirements of the Marchman Act, which means there's no hearing, no lawyer. We're going to file our pleadings, and the court is going to decide if it is legally sufficient. And if it is, and that we can establish that there's a reasonable basis for the request, the court's going to authorize the police to go and pick that person up and take them to a designated receiving facility where they can be held for the period of time. 72 hours, again, extending out potentially up to 10 days, depending on the facts of the case. Now, in our situation, we're going to use, as a general rule, we don't just use the police. We have our guy go out there, or a member of our team go out there to make sure that things go smoothly, especially if we have to go looking for the person. Now, the second part of this is that period of treatment. That requires a hearing, because even though this is civil in nature, mum and dad versus son, mum and dad versus daughter, whoever it may be, and these days it could be mum and dad versus the they them, because we are seeing a lot of transgender individuals coming into the office. So we want to be respectful and mindful of those individuals too. But in any event, this is civil in nature, but because we are looking to take somebody's liberty away, well, the constitutional protections that we would associate with a criminal case apply. The right to a hearing, the right to counsel, the right to remain silent, the right to make us meet our burden of proof, which at this stage of the proceeding is clear and convincing evidence, right? The right to confront witnesses against you. All of these things that we would associate with a criminal case apply now in this civil proceeding, because we are now talking about taking someone's liberty, potentially for up to 90 days, which is the maximum at any one time under the Marchman Act. And that 90 days can be extended. And as an example, I had a young man who came here from Arkansas. I had him under a Marchman Act for 2 years. And every 90 days, I went back into court and asked for an extension, and we got it. And so it's a powerful tool when used correctly. So here are some of the changes. I think I mentioned some of them. Only one petition. It used to be that we would have to tell the court when we filed our petition for treatment services, the second petition, what was in the assessment. We no longer have to do that. And here is, I'm just going to point this out, where it says the assessment period is 72 hours and less. Remember I said to you, it can be extended out. The respondent shows signs of withdrawal or need to be either detoxified or treated for a medical condition, which shall extend the amount of time the respondent may be held for observation until the issue is resolved, but no later than the scheduled hearing date, absent court-approved extension. So again, we can move this out, but it depends on the facts of the case, right? As a general rule, it's going to be 72 hours, but again, it can be moved out and extended a little bit longer. Okay, this is just some of the things that we went over here. Hearings within 10 days, right to counsel, maximum time under the Marchman Act is up to 90 days. Again, we can extend it, and you'll see here we have the burden of proof, a bit like the prosecutor in a criminal case. We have to prove our case, except the standard is clear and convincing evidence, as opposed to when I was prosecutor, beyond a reasonable doubt. So a little bit lower standard, but still got to come to court with evidence. And as lawyers, we're still bound by the rules of evidence, the rules of procedure, and substantive law. So you really got to know what you got here with these cases. You're going to handle them. And everybody in my office is an experienced litigator, so we're comfortable in the courtroom. But sometimes these cases, can become adversarial. That's part of what we do. That's part of what we're dealing with. So let's talk about guardianship, and that is a photo of my amazing, beautiful wife, Audra. So you see I have in there parentheses, primary mental illness. Why do I have that? Well, remember I told you there was this big shift in our cases. COVID came along, legalization of marijuana, and by the way, here in Florida, they're looking to amend the Constitution so we can have recreational marijuana. I think that's going to be probably a recipe for disaster. I've spoken to folks in other states. Actually, I was just speaking to a clinician yesterday who was in Vermont, and she told me it's just been an absolute, it's been a disaster. It really has been, and it will be a disaster here in Florida. But the simple fact is that it's available on the streets anyway, and it doesn't seem like it's that difficult to get a card, even for the medical marijuana. And I think one of the things that we're seeing is that we speak to families and they say, well, their loved one has a card, so it must be okay. And no, just because they have a card doesn't mean it's okay, and that's very destructive. In any event, you'll see I have here, is it just for the elderly? Well, I mean, before Audra and I started doing guardianship work together, it was a statute. People would think, well, this is just for the elderly. And we, even to this day, we get calls from families who say, well, I spoke to my probate lawyer, my estate planning lawyer, and they said you can't do a guardianship case for someone who has mental illness. And there is a really big difference between handling a behavioral health case like we do and an elderly case. They're obviously, a lot of the time, they're adversarial. There's all these different dynamics that go on with somebody who's very sick with a behavioral health issue. And so, yeah, I mean, we've been doing this successfully now for the last 9, almost 10 years, where we're getting guardianship over people so that families can get a lot more control. And I'm going to talk about that aspect in a second in terms of the control. But needless to say, guardianship is a very, very powerful tool because it gives you way, way more control than a Marchman Act. So, as a child of the 80s, for those of you who are similar in age to me, I'm going to be 58 in January. This is the DeLorean time machine from the Back to the Future movies. And I have this up here because guardianship really is a time machine. It's a legal time machine. And what do I mean by that? Well, when somebody is, considered an adult here, 18 or over here in Florida, that means they get to make their own decisions. They can go buy a house, they can get married, they can open up a bank account, they can do whatever they want, right? One of which is they can say they're not going to go to treatment, even if they do have a behavioral health issue, even if they have refused to go into treatment in the past, even if they have had an overdose, even if they are not able to work and function and do all of the things that are necessary to be a productive member of society. So what do we do? What do we do with guardianship? Well, we jump into our legal time machine and we say to the court, Your Honor, I need to be able to make decisions for my loved one because they are simply not capable of making them. They are placing themselves at great risk, and I need you to allow me to turn the clock back as if they were under 18 and they were no longer legally entitled to make decisions for themselves. I need that authority. So we jump into the DeLorean and the court allows us to start making decisions for their loved one. That is the whole goal. That's why it's a time machine. That's what guardianship is really all about, turning the clock back to a time when the parents or whoever the guardian is, it's usually the parents, had the right and the authority to make decisions for their loved one. So you might recall I talked to you when we talked about Marchman Act. I said what's cool about the Marchman Act is that we can initiate the period of assessment on an emergency ex parte basis, right? There's also an emergency section to the guardianship statute. Now, you probably won't see that in an elderly guardianship, but we see that a lot in the cases that we do. I would say that 95% of the guardianship cases that we file, and by the way, we file them in hand, sometimes in combination with a Marchman Act. Oh, and by the way, the person gets Baker Acted in the middle of all of this craziness. But a lot of time we're filing what's known as an ETG, Emergency Temporary Guardianship. Okay, and just as it says, it's granted on an emergency basis and it's temporary in nature. Good for 90 days. A bit like a Marchman Act is good for 90 days. Now, that because of the way the statute's written, that requires a hearing. Now, if you file a typical, petition for permanent guardianship and a petition for incapacity, which are the other two petitions that have to be filed along with a petition for emergency temporary guardianship, you'll probably get into court in 3 or 4 weeks. We don't have time for that. I mean, we've got somebody who's in crisis right now. We need to give the parents some authority right now and get that person into treatment. So we can normally get into court on an ETG petition 24 to 72 hours, depending on which court we're in. When I say court, I mean the county that we're in, because some counties are busier than others, and it just depends on how busy the court is. But typically 24 to 72 hours to get into court. We don't need an expert. I recently handled a case where actually I was representing the wife against the husband, and we just put the wife on to testify. And she got halfway through her testimony, and the judge said, "Okay, I heard enough, Mr. Astor. This is getting granted. So I just need a witness to come in and tell the court what's going on." Once the petition for permanent guardianship and the petition for incapacity are also filed, the court's going to appoint what's known as an examining committee. 3 court-appointed experts who will determine if this temporary guardianship will become permanent in nature, and if so, what rights are going to be taken away or suspended so that we can continue to make decisions past 90 days. And by the way, a little bit like Marchman Act can be extended for another 90 days, so can the emergency temporary guardianship, if need be, and if there's a reason why the examining committee didn't do their job within 90 days. But needless to say, it can be extended if need be. So here's the criteria for the granting of an emergency temporary guardianship. So you'll see here we're under Section 744 of the Florida statutes, 394 is the Baker Act, 397 is the Marchman Act. And it says here, the court must specifically find that there appears to be imminent danger that the physical or mental health or safety of the person will be seriously impaired, or that the person's property is in danger of being wasted, misappropriated, or lost unless immediate action is taken. So here in Florida, we just have guardianship. Now, there are some states where they have guardianship and conservatorship, and the difference being is that one is sort of a court order regarding the person, and on the other, this is a court order regarding their property, their money. Right? Perhaps we need to get control of a trust fund or access to money, things of that nature. Here in Florida, it's one petition, so we are going to ask for what we need. We need the ability to get them into treatment here, make medical decisions. We also need to control their finances because they're going to use that money not only to fund some type of illicit lifestyle, but perhaps they'll go buy a plane ticket and look to leave. So we might need to get control of all of those things. And here are the rights. Here are the rights that can be taken away. So the right to vote, to marry, to contract, to defend lawsuits, to travel. That's a big one. That is a big one. And let me give you an example of that. So we had a client, we actually were representing a lawyer. He had an adult daughter, early 30s. She was very successful in business, attractive. You would meet her and think she was just terrific. But if you put a bottle of hand sanitizer on the table and you turned away for a second, she'd drink it, the whole lot. She had a very, very serious dependence on alcohol. And so we said to the father, look, you really should get guardianship over her. It's going to give you a whole lot more control, right? We could have asked the court to give us the ability to, basically to take these 12 rights away from her. The father said, no, I'm not doing it. I just want to file a Marchman Act. Now, remember, I told you sometimes we'll do Marchman and guardianship together. Marchman's very quick. Guardianship's very broad. See, here's the 12 rights that we can potentially take away. Marchman Act is very narrow. Right? It's a court order that says, Mark, you will go to treatment for up to 90 days. And if you're not compliant, you don't do what you need to do, or you walk out, well, then you're coming back to court to have a conversation with the judge about what kind of sanction you might face. Right? But mom and dad have just gotten this court order. They've spent a lot of money to get you into treatment, spent some money on a lawyer. And now mom and dad call the treatment facility and they say, how is my son doing? How's my daughter doing? And the facility says, I'm really sorry. They are mad at you. They refuse to sign a release of information, and we cannot confirm or deny they're even here. And their parents are like, well, hold on a second. We just saw you take them from the courthouse into treatment. We just gave you a check for X amount of dollars to pay for treatment, and now you're telling us that you can't talk to us? Yeah, that's what we're telling you. Because the Marchman, this filing, all of these filings are for the most part confidential in nature. And so they're protected by medical privilege, which means if your loved one doesn't want to sign a release of information, guess what? The facility's not going to be able to talk to you. Well, if you have a guardianship, they can talk to you, right? So much broader in application. Let me just go back to what I was talking about with the case and the lawyer. So he didn't want us to file for guardianship. We just filed the Marchman Act. And at the end of the hearing, the daughter said to the judge, I know I'm being sent to treatment, but I would like to have access to my computer and my cell phone for 24 hours. Would you mind? And the judge said, what do you think, Mr. Astor? I said, no, you should not give it to her. He said, I'm going to give it to her anyway. We put her in a facility in the middle of, there was just basically a building in the middle of sugarcane fields, as far as the eye could see. The idea being, we figured, if she walked out, where was she going? The cornfield? Well, in the middle of the night, she used her cell phone to call for an Uber. They came and picked her up. They took her to the airport, and she got on a plane and went to Mexico. That's the case where John went down to Mexico and brought her back. Because when she got down there and realized she'd made a very silly decision, and now she was extremely vulnerable. So John went down there and then basically, helped her to come back. He wasn't dragging her back, but he said, look, I'm here to help you. And, he found her and got her back. But had the father allowed us to file for guardianship, which ultimately he did, one of the things that we could have done was we could have restricted her ability to travel. Sorry, can't get on that plane. The other things that we can look to suspend: the right to have a driver's license, choose your residence, where you live, making mental health decisions. You need to go to treatment. We're making that decision for you. The right to make that has been taken away. Seek employment, your social environment, who are you spending time with? Applying for government benefits. That's a big one, right? Is the person entitled to any kind of governmental benefits as a result? If they are, well, they can't apply because they've just been declared incapacitated. They can't file on behalf of themselves, but the guardian can. The guardian can. And what about managing property? Perhaps they have assets that need to be protected. Now the guardian can do that. So you see, the guardianship is a really powerful tool, right? Very, very broad in its application, as opposed to Marchman, narrow in application. But again, they have their uses, right? And done together, remember, Marchman Act is primary substance use. If we can prove substance use, then we can do them together. So now what I'm going to do is I'm going to file the ex parte petition in my Marchman Act, get them picked up, get them to a place of safety, right? In the meantime, I'm running to court on my emergency temporary guardianship petition. I get a temporary guardianship, right? We're also moving forward on the Marchman Act process, setting that for a hearing. In the guardianship case, the court is appointing the examining committee. So all of these things are going on. Everything's moving together. But these things, they work together. And understanding how they work together and understanding the different sort of criteria and being able to handle these cases in the different courtrooms is really, really important. Okay. And it's critical to be able to do a great job and get this person into recovery and keep them there long enough. Oh, this has become a favorite topic of mine. The wonderful Baker Act. So it's been almost 8 years since I lost my father. And just a couple of days after I buried him, I had a close family member who got Baker Acted. I was there with the police, the paramedics, and it was horrendous. Okay, now I'd heard about the Baker Act from my days as a prosecutor. You know, the Baker Act this, the Baker Act that. They got Baker Acted, but I'd never experienced the Baker Act until that day. Okay, which would have been January the 17th, almost 8 years ago. So then COVID came along. As I told you, two things really, really changed the dynamics of the kinds of cases that we get, right? With COVID. COVID was the biggie, at least as far as the Baker Act is concerned. And I started getting calls from other lawyers. They'd had a family member who was Baker Acted. They had a client who was Baker Acted. And they said, hey, can you help us? Can you help us to get this loved one out? Now, before I really got into the Baker Act, and at this point in time, I've probably filed almost 500 cases now to get people out of the Baker Act. And I've spoken to thousands of people over the last several years about being unlawfully, wrongfully Baker Acted. But the sort of understanding was, well, it's a 72-hour hold, nothing you can do about it. And I started reading that statute and I said, I think there's a lot we can do about it. And we have been doing a lot about it. But let's talk more about the Baker Act. Again, this is a statute that focuses on mental illness, right? And what's important here, and I'm not going to get into all of this because we're running out of time here, is that basically where somebody has a mental illness, they are presenting as an immediate danger to themselves. That means that we don't have time to run to court to get a court order. We need help right now. Now, there are three ways. I don't know if we have it here. There are three ways to initiate a Baker Act, and I meant to add this in here. I apologize if I didn't. 3 ways. Let me talk about that because it's important. Number one, it's initiated by law enforcement. Police get called to the scene. They can initiate a Baker Act. The issuance of a professional's certificate. Somebody like a licensed clinical social worker, an emergency room doctor, a psychiatrist. It issues what's known as a professional's certificate, a 2-page document where they say, here's the criteria, this person meets them, and I need law enforcement to come here and take this person to a receiving facility. The third way of initiating a Baker Act is if you go to court and actually file an ex parte petition for assessment, a bit like you would do under the Marchman Act. And what that does is that kicks in those 3 methods of initiating a Baker Act, kick in the 72-hour hold for an involuntary Baker Act. And there's 2 types of Baker Act here in Florida, and I'm going to talk to you about that in a second, because, again, that was one of the things that I learned when I really started to get into the weeds with the Baker Act. But when it comes to the Baker Act, we're talking about somebody with mental illness, okay, who is an immediate danger to themselves, okay? And I just want to point out here what the Baker Act does not include. Okay, a substance use, somebody who's drunk, high, okay, somebody who has some type of medical condition or a traumatic brain injury, okay, a developmental disability. Now, the reason I wanted to share that with you is because over the years we've seen some really wacky cases with the Baker Act. I've had 80-year-old men who were terminally ill with cancer, Baker Acted. I've had people that were drunk, Baker Acted. I've had people that were high, Baker Acted. I've had people who had some type of traumatic brain injury, Baker Acted. I've seen a number of cases where we had children, young adults who had autism, which is a developmental disability, getting Baker Acted. I've had a woman who had an emergency C-section, Baker Acted, right after she gave birth. I've had a woman who went in there because she went into labor 2 months early, Baker Acted. I mean, just the most insane, crazy stuff with the Baker Act. Well, why is that? Why is there such a problem with the Baker Act? Okay, a couple of reasons. First of all, let me tell you what the Baker Act is not. It is not a treatment statute. It is not designed to treat anything. Now, I get calls pretty much on a daily basis. People call me and say, well, my loved one needs help. Can you help me to file a petition for a Baker Act? And I say, well, are you trying to get them into treatment for some type of ongoing issue? I am. Then don't Baker Act them. Do not Baker Act them. It is not a treatment statute. The Baker Act is a statute that allows the state of Florida to take custody of somebody when, as I pointed out earlier, when there's a mental illness issue. And so what happens is that people, I've had instances where I had an elderly man who his wife was having some issues, and he'd called the police a couple times and they said, file a Baker Act. Well, he ran down to the courthouse, he filed this emergency petition under the Baker Act, and then the cops showed up after the court granted it and took his wife to a Baker Act facility. And then he couldn't get her out. So instead of helping her, I mean, it was a disaster. So the reason for that is because once he had Baker Acted her, she became a temporary ward of the state of Florida. His rights to make decisions for his wife were terminated. They were over. Her rights to make decisions for herself were terminated. They were over. Why? Because now the state had become the legal guardian. And the patient had become the ward. Just like in a guardianship case. Which is why, if you have a loved one who has a primary mental illness issue, you should be filing for a guardianship. The only time that you should be seeking the initiation of the Baker Act is if and when this is an emergency situation, meaning it's the kind of situation where you would call 911. That's what it's designed for. The idea behind the Baker Act is that if we have somebody who is in immediate crises because of a mental health issue, we want to be able to pick up the phone, call 911, ask for the police to come and help us, right? Ask an emergency room doctor for help if we have to take them to the ER. We want to be able to get emergency relief right now. But here's the number one problem with the Baker Act. Once you have a loved one who is Baker Acted, nobody knows they're there. And I mean no one. The facility doesn't report to anybody. Now, when I was a young prosecutor, I had to go to what's known as first appearance. So here in the criminal justice system here in Florida, if you get arrested and you get taken to the county jail and you can't post what's known as a scheduled bond, you get before a judge within 24 hours. You have to. Matter of procedure. You automatically get to see a judge to address three things. Number one, the legality of your arrest. Was there probable cause to arrest you? Number two, you have a right to counsel. If you cannot afford a lawyer, the court's going to appoint one for you to protect your other rights. Counsel. And number three, what's a reasonable bond? What are reasonable conditions of release? Because we don't want people sitting in jail who are, one, presumed innocent, but we do want to make sure they come back to court because now this case is going to proceed through the criminal justice system. So you get arrested here in Florida and you are still in the county jail the next day, you're going to see a judge as a matter of law. Well, here in Florida, you get Baker Acted. You know who you're going to see? No one. No one. There's no process for making sure this is done legally. And that has been my gripe for a long time about the Baker Act. And we just had these changes, as I mentioned, July the 1st, and they completely missed the boat. I'm really sorry, but they did. In any event, two types of Baker Act. Now, the one I talked about, which is initiated one of three ways, is the involuntary Baker Act. Okay, good for up to 72 hours once the person reaches the receiving facility. So if they went to a hospital first, say for an overdose, be it intentional or accidental, and they required medical attention, the 72-hour clock doesn't start to tick until they either go into a behavioral health unit, if the hospital has one, or they are admitted at a Baker Act receiving facility, because sometimes people get transferred from hospital to facility. Here in Boca, where we're based, Boca Regional doesn't have a behavioral health unit. They send their patients to Fort Lauderdale Behavioral Health. So the person gets transported across county lines down to Broward County. The clock starts to tick once the person reaches Fort Lauderdale Behavioral Health. That's when the 72 hours starts to tick. Now, there's also what's known as the voluntary Baker Act. Well, Mark, why would anybody ever agree to be Baker Acted if they're going to become a ward of the state? Well, during COVID, lots of people became wards of the state on a voluntary basis. They, as I said, they were showing up at ERs, they were showing up at Baker Act receiving facilities, and they were getting sucked into Florida's mental health system. And because nobody knew they were there, they couldn't get out. So, the involuntary Baker Act, good for up to 72 hours. Okay? Now, what happens at the end of 72 hours? Well, one of three things is supposed to happen. And remember, if nobody knows you're there, who makes sure that it's done right? Oh, and here's the icing on the cake. The Baker Act receiving facility is a licensed agent of the state's mental health system. And as a result, they enjoy immunity like any other state agency. So you can't sue them for this stuff. If you get hurt, and we had an instance where we had a girl that was raped in the facility, that's a different story because they have a duty to keep you safe. But if they don't follow the law and you didn't get harmed, you're not able to sue these people, right? So nobody knows you're there. You can't sue them for this. So, I mean, you can just, and there's no due process automatically built into the statute, so you can see where this might go wrong, right? So 72 hours. At the end of 72 hours, one of three things has to happen. Either file a petition for involuntary placement, meaning they're asking the court to give them an order for extended detention. That kicks in a hearing that takes place within 5 days, and you could, in theory, be sent to a state hospital for up to 6 months. And I've seen it happen. So they either have to file to keep you, they have to release you, or they get you to agree to remain there on a voluntary admission basis. That means you have to give informed consent. You have to understand that if you agree to be there on a voluntary basis, that your detention is potentially indefinite without a court order. Let's come back to the changes in a second. Well, why would you agree to this? Why would you ever give informed consent? Well, what tends to happen in the cases that we handle is somebody is coerced into signing a voluntary admission agreement. If you don't sign this, you'll never get out of here. If you don't sign this, we're going to stick a big needle in your backside and you won't be in a position to make any decisions. If you don't sign this, this will happen or that will happen. You'll never get out of here. I mean, these kinds of crazy scenarios. Or they just say, hey, sign here, which is what was happening during COVID. Sign, you want an assessment, right? You want us to figure out if your medications are working or if you need a new med. Sign here. You just signed a voluntary admission agreement. Now, if you sign voluntarily, for whatever reason, and you say, I want to leave, the facility doesn't have to let you go. Remember, you're in a locked, secure facility. This is like jail, but worse because nobody knows you're there. In theory, the way it is supposed to work is that if you request to be released, known as an RTR, request to release, the facility has to do one of two things in 24 hours. They have to let you go, or they file that petition for placement that I mentioned, at the end of the 72-hour period. And that kicks in the 5-day hearing requirement. And at that hearing, you can still be detained up to 6 months. So the Baker Act is a convoluted mess. And I'll leave it at that. Okay, we're running out of time here. I got about 5 minutes. So here's the big one. The big change here is this second requirement that law enforcement may take a person who meets criteria into custody. So if law enforcement get called to the scene, remember I told you they're an agent of the state's mental health system, in addition to being an agent of the state's criminal justice system. Well, it used to be if they made a determination that you met criteria, they had to take you. Now, if they determine that you meet criteria, they may take you. So we've given law enforcement, and I have nothing but respect and admiration for law enforcement, but we've asked law enforcement to make a clinical decision, and we've just given them more discretion to do it. I think that was a mistake, but that's just me. Okay, I think I mentioned the criminal courts. We've got all these new courts that have come along: mental health court, drug court, veterans court. Very quickly, will this go on my record? The Marchman Act and Baker Act are confidential filings. Does that mean that it'll never be found? It could well be found. And one of the things that we're seeing here is that people are getting Baker Acted and or Marchman Acted are losing their Second Amendment right to own or possess a firearm and to carry. So that's a separate issue that we're dealing with. But unlike a criminal case, it cannot be expunged. Whatever's there is there forever, and I cannot remove it, unfortunately, which is very frustrating for a lot of people, especially when they get wrongfully Baker Acted and this thing's out there forever. Some of the challenges that we deal with, I think the big one is sometimes when we speak to parents, getting everybody on the same page. Another big challenge for us is by the time people get to us, they're pretty beaten down. The idea that there may be an end to this years-long nightmare is so almost foreign to them. It's hard for them to understand that we can help them. We have phenomenal results in our office, but I don't have a magic pill. I don't have a magic wand, right? This is going to take time. But the catalyst for all of this change is getting your loved one into treatment and keeping them there long enough. That's the key. And when we do that, seeing that miracle, because it really is a miracle, is just a sight to behold. So if you're a family out there, there's hope. I have hope for you. Okay, this is my contact information. Mark at AstorSimovicLaw.com. I already put my email into the chat there. There's the main number to the office, 561-419-6095. There are the websites, mentalhealthaddictionlawfirm.com, bakeractattorneys.com, and you can find me pretty much all over social media. I try to do a video almost every single day. I'm really a big believer that if you're a family and you have a loved one in crisis, you need to get the information, and you shouldn't have to pay me or anybody else to get it. You should get it for free, right? And if you want to have a chat with us about how we can use the legal system to get your loved ones treatment, happy to do so. Okay, call the office, speak to Brittany, who runs my intake department. She's terrific, and she really gets it. She actually has a background. She worked for many years in the Department of Juvenile Justice, so she sees what happens to young people when they don't get the treatment they need, and she's just amazing. If you're a lawyer and you're watching this, the Florida Lawyers Assistance Program, I can't tell you how many lawyers we put into treatment. The Florida Bar will help you. Florida Lawyers Assistance. And there's the number for the hotline. And lastly but not least, if you're a lawyer and you're watching, this is the CLE credit number. So if you're going to get you 1 hour of credit, this is the number that you need when you go to your Florida Bar profile. This is the number that you need to put in. So in any event, I think we've been going for 58 minutes here. Thank you for tuning in. I don't know if anybody has any questions. Let's see if we can turn this off. There we go. I'm back. Okay. It's taken me a little while to get used to this technology. In any event, I'm very grateful for anybody that's tuned in. This is getting recorded. I'm sure that we're going to replay it. If you have any questions, there's on both of the websites, there's an ebook. You can download it. It talks about Marchman Act, guardianship. We have on the Baker Act site, there's another ebook talking about real cases, because when nobody knows you're there, well, it's very easy for you to be abused. And I live in the real world here. You don't need me to interpret the statute. You can read that for yourself. Um, in any event, I'm very grateful. Thank you so much for tuning in. We're going to keep doing these. If you have other ideas for another sort of LinkedIn Live presentation, I'd be happy to do it for you. And with that said, if you are in Florida watching this, we have the hurricane coming. Be safe. Take care of yourself. And I will see you in the next one. Thank you for tuning in. Take care. Bye bye.